In a typical cybersquatting case, a trademark owner files a complaint to recover a single domain name. However, domain name dispute policies, such as the UDRP, the Uniform Domain Name Dispute Resolution Policy, allow a trademark owner to include multiple domain names in one complaint, which can make the process incredibly more efficient and cost-effective. Hi, I'm Doug Isenberg, an attorney and founder of GigaLaw, a law firm that helps clients protect their brands on the internet. In this video, I'm going to talk about when it's appropriate to include more than one domain name in a UDRP complaint, how you can do so, and why trademark owners should always consider this possibility, which has the potential to significantly reduce the effective cost of the UDRP process. A number of years ago, I filed the largest complaint that has ever been filed under the UDRP, which resulted in an order transferring 1,519 domain names to one of my clients. Large UDRP cases like that one are uncommon, but complaints with 2, 3, 4, or even 10 or 20 domain names are not unusual. That's why it's usually worth the time and effort to consider any additional domain names that might be relevant to a complaint before filing. Creating a complete picture of all relevant domain name registrations and the affiliated parties has the potential to become complex, which I'll describe in a moment. But this is an important and potentially time and cost-saving step I always discuss with my trademark clients when pursuing cyber squatters. Still, many trademark owners will consider filing a UDRP complaint when they come across only a single offending domain name. And in fact, most UDRP complaints include only one domain name. But identifying multiple domain names for possible inclusion in a single complaint is an important part of the overall process. That's why it's essential to know when and how to file a UDRP complaint for more than one domain name. At the outset, I should note that the UDRP itself does not say anything about how many domain names can be included in a single complaint, but it does contemplate that a case is not necessarily limited to only one domain name. Specifically, the UDRP rules say the complaint may relate to more than one domain name, provided that the domain names are registered by the same domain name holder. So the key issue when it comes to pursuing a complaint against multiple domain names is really, what is a domain name holder? That term is not defined in the UDRP or the UDRP rules, so panels have had to interpret that phrase and apply it through the years in lots of cases. In some cases, it's obvious that multiple domain names are held by the same domain name holder, especially if the Whois records, which are essentially part of an online database of information on domain name registrations, identify the same person or entity as the registrant of multiple domain names. For example, if the Whois records show that John Doe has registered two domain names that are both identical or confusingly similar to a specific trademark, then it is probably appropriate for a trademark owner to include both of them in the same UDRP complaint. That's the simple case. But what happens when the Whois records are incomplete or unavailable, as often happens with privacy or proxy services, or because of the European Union's GDPR, the General Data Protection Regulation? Or what if the Whois records identify two different registrants, but it appears as if the different registrant names are actually just aliases for a single person or entity? That's a pretty common situation, in part because some cyber squatters are smart and register multiple domain names under different and often fake entity names, knowing that doing so is a simple way to avoid detection. Although domain name registration policies require registrants to accurately identify themselves, many cyber squatters just don't do so. And I've seen plenty of them use a variety of names and contact information, knowing that doing so will only make it more difficult for trademark owners to pursue them. But fortunately, the UDRP recognizes this trick. As one panel wrote in a UDRP decision involving 17 domain names, The mere fact of registrants being differently named has, in various previous cases, not prevented a finding that there is one proper respondent, in circumstances which indicate that the registrants may be regarded as the same entity in effect. And in another UDRP case, which involved 25 domain names, each of which was registered to a different named entity, a UDRP panel said that the named respondents may be considered as aliases for a single person or entity and will allow the multiple respondents. Indeed, this is such a common occurrence that the WIPO Overview, a publication about the UDRP from the World Intellectual Property Organization, lists a number of factors to consider when deciding whether such so-called consolidation of multiple domain name registrants is appropriate. These factors include the registrants' identities, including pseudonyms, the registrants' contact information, including email addresses, postal addresses, or phone numbers, including any pattern of irregularities, relevant IP or Internet Protocol addresses, name servers, or web hosts, the content or layout of websites corresponding to the disputed domain names, the nature of the marks at issue, such as where a registrant targets a specific sector, any naming patterns in the disputed domain names, the relevant language or scripts of the disputed domain names, particularly where they are the same as the trademark at issue, and any pattern of similar respondent behavior. In UDRP cases that I've filed for my clients through the years, I've successfully been able to include multiple domain names in a single complaint, sometimes by arguing that just a couple or a few of these factors exist. In other words, it's certainly not necessary to establish all of them. So, what's the advantage of going through this exercise? The short answer is that it's like the old expression of killing two birds with one stone. If a trademark owner can include more than one domain name in a single UDRP complaint, then it can capture, recapture, or take down multiple domain names at once, which makes the UDRP process even more effective. Among other benefits, these larger complaints are economically efficient. Here's why. As I discuss in another video about the costs of a UDRP complaint, the typical filing fee is about $1,500. At WIPO, for example, this filing fee includes up to 5 domain names. So a complaint with, say, 2 domain names would reduce the filing fee to effectively only $750 per domain name. And if the complaint included 5 domain names, the effective cost would be reduced even further to just $300 per domain name. Now, the filing fees do start to rise as the number of domain names increase, and they vary by UDRP service provider. And legal fees can certainly increase with larger complaints too. But still, every large complaint I've ever filed is significantly less expensive on a per domain name basis than those with only one domain name. As I said earlier, large UDRP complaints are the exception. The average number of domain names per complaint is about 1.6, and most include only one domain name. There's absolutely nothing wrong with that, because most of the time pursuing even a single domain name is still important for protecting a trademark owner's brand on the internet. And trying to identify multiple domain names that belong to a single holder is not always an easy task, but it's something I like to discuss with my clients to ensure that they get the best possible result when filing a domain name complaint. To learn more about domain name disputes, I invite you to take a look at other resources on my website at www.giga.law, where you can also subscribe to receive a daily email newsletter about important developments in internet law. Thank you.